Okay. Oops. Someone needs to be admitted, right? Right, so today's topic is going to be the Paris Agreement. You may have heard about the Paris Agreement. So after today's session, you're going to know all about the Paris Agreement. Okay. And it's by far the most important framework now available for us in international law to address climate change. So that's the reason why I've picked it up right at the beginning, or nearly at the beginning of this particular course. So this is how the lecture structure is going to be today. We look at some of the overarching issues about the nature of the Paris Agreement. We will look at what architecture was decided upon and in what stages, in what forums for the Paris Agreement. We'll consider the scope. What are the different topics, themes, issues it was meant to cover? And then what finally has appeared in the provisions of the Paris Agreement. So we'll go through some of the key articles in the Paris Agreement so we can understand the key content of the agreement. What was agreed upon by parties, and that'll give us an opportunity to reflect on what we see is the international course of action for addressing climate change and reducing global warming. And then finally, we'll look at the significance of the Paris Agreement in the wider context of the United Nations Framework Convention on Climate Change, which is a whole family of different instruments put together. So within that context, what is the significance of the 2015 Paris Agreement? At the end of this session, I'll also remind you of the assignment question and give you some tips about how I expect you to go through the assignment question, to answer the assignment question. All right, and we'll have an opportunity to discuss in terms of what you've thought so far on the work. I'm certainly a great fan of getting into an assignment as soon as it is offered out. Okay, so I expect all of my students on this course to adopt the same approach. So I'm going to nudge you along in case you haven't given it thought from last session to this session. I am going to nudge you along by getting you to think a little bit more about how you might do your assignment. So let's go on to the first topic. We all know, it's nearly 9 years since the Paris Agreement was first forged, and we take it for granted. We take the Paris Agreement to, just to have happened. But let me tell you, based on the negotiations in the run-up to the Paris Agreement, that Paris Agreement was not a foregone conclusion. It wasn't sure that the agreement would happen. It wasn't sure that it would happen in the way it did eventually happen. Okay, so that's why what you need to know is that Paris Agreement was a effort which took a lot of strategies to bring it into fruition. So two key things it tried to do, which was different from the previous agreements of the United Nations Framework Convention on Climate Change. First, the parties that were negotiating tried to change the obligations of states towards climate action. So previous obligations, you had mitigation obligations that fell only on developed countries or industrialized advanced nations. But what the Paris Agreement negotiating parties wanted to recognize was that increasingly countries other than the developed countries were emitting GHG at a fast rate, at quite a pace. So therefore, we needed some kind of framework to ensure that those countries also did not develop, far down in that trajectory of being high emitting. So obligations towards climate action needed to fall on both developed and developing countries. And the Paris Agreement succeeded in finding mechanism to do that. So it tried to change the obligations of state, and it succeeded in changing the obligations of the states. Secondly, it tried to intensify the managerial approach, and it succeeded in doing that as well. As we go through the provisions and the way the Paris Agreement is set up, you will understand more what is meant by the managerial approach and the intensification of the managerial approach. But for now, suffice it to know that Paris Agreement intensified managerial approach, which is very much a feature of climate change law, and quite a distinctive feature of it too. Overarching issues to be considered. Firstly, the Paris Agreement is a legally binding treaty. And this was an issue that came up in the run-up to the draft creation of this agreement, because not all countries actually favor this approach. India, Brazil, and China objected to this approach. Okay. And then you had the AOSIS. Okay, this is supposed to rhyme with oasis. And oasis, no, AOSIS, this is the Association of Small Island States. If you stop to think about what the position of the small island states is within climate change, you'll realize why they take the positions that they do. Okay, so they have an existential threat to their countries because of climate change. So this group, EU, the European Union, United States, all of them favored a legal binding treaty. Yeah. At the end, we did get a legally binding treaty, and that is the Paris Agreement. Is the Paris Agreement? How do we classify it in international law? So to look at whether it amounts to a treaty, we look to see whether a particular legal instrument or an instrument that claims to be a treaty falls within the definition of the Vienna Convention on the Law of Treaties, for short VCLT. And we look for the conditions in Article 2.1a, and we're going to see whether if it satisfies 2.1a, then it is under international law an international treaty or a legally binding treaty. So at this point, recall in the very first lecture for this module, what I said about the nature of climate change law. So climate change law is not a self-contained body of law. It takes rules from international law as well. So in this case, it's taken a rule relating to legal form, and that is the legal treaty under the Vienna Convention on Law of Treaties, which is part of the body of public international law. So under Article 2.1a, if anything is concluded between states, and that's presented in a written form, and it is agreed that this is governed by international law, then it qualifies that kind of a document to be considered a treaty. And in the case of the Paris Agreement, all these three conditions are satisfied, and therefore we can confidently consider it to be a legally binding treaty under public international law. Next issue, is that it sits within and it conforms to the United Nations Framework Convention on Climate Change. The Paris Agreement is an agreement under the UNFCCC. What does it mean to say it is a treaty under another treaty? That means both these two treaties have to be read in a way that the purpose of the second treaty is really embedded or flows from the original treaty. So the original treaty was meant to be spawning other treaties because in its name, it says Framework Convention. So it's a framework for devising further rules. Okay, so in this case, what we are seeing is Paris Agreement now contains the rules. So when did the UNFCCC come into existence? 1992. And when did the Paris Agreement come into existence? 2015. Okay, a lot of things happen in between. In one of the later lectures, we will look at how international climate lawmaking happens. Okay, and then we'll go into a bit more detail about what happened in these intervening years since the UNFCCC came into existence and later on in 2015 when the Paris Agreement came into existence. So the Paris Agreement is a legal instrument that's related to UNFCCC. It is tied to the main purpose of the United Nations Framework Council on Climate Change. Framework Convention on Climate Change. And then the purpose of the Paris Agreement is to enhance the implementation of the United Nations Framework Convention on Climate Change. Now, this last one is really crucial from a legal point of view. Okay, you could write a lot about to what extent the Paris Agreement enhances the implementation of UNFCCC. So another question I raised in my first lecture was effectiveness of climate law. Okay, a part of that answer to that question will be instruments like the Paris Agreement help enhance the effectiveness, right? So one of the ways in which I said you could measure effectiveness is to see how a treaty has done in terms of politically, whether it was able to push ambition to the highest possible level at that point. So we could say that the Paris Agreement moves forward very much in that direction. It pushes politically what is being agreed at the international level, because without this, we will not have that concerted progress that is necessary. Now, whether it is satisfactory and affects or addresses the problem of global warming is another question of effectiveness. Okay, so we ask these layers of questions. You could use the Paris Agreement to answer one of those questions. Okay. So for all these reasons, then Paris Agreement is central to the United Nations climate regime. So this module itself is about legal aspects of climate change. And so far, one of the biggest legal aspects has been international climate change law. And we've already had glimpses of other aspects of legal aspects that are not international, but domestic and even subnational, which we haven't touched upon yet, and we'll touch upon it in the future. But what pulls all of this together is the Paris Agreement. So it is central to the UN climate change regime, which is central to all of the legal aspects or legal implications of climate change so far that we've tried to put in place. Okay. Now, before going into the other issues in overarching, I want to try and see if we are able to play a little video. It's quite a funny video, so let me see if I can share that with you guys. Right, so Right. Okay. Now you're going to see, excuse my screen. It's got loads of tabs, but it's also got some attendant YouTube videos, which you don't want to necessarily pay attention to. But now that I've said it, I'm sure that's what you're looking at. But all right, now you're going to have to tell me if you can see the screen.
Yes, please, we can see it.
You can see the screen. Next is the, so the screen that you can see is the YouTube video screen, right?
Yes, please.
All right, and not the PowerPoint. Okay, but I'm gonna have to perhaps come out. I'm not sure you can listen to the sound if I. So just tell me if you can hear the sound, huh? Can you hear it?
No, please.
Okay,
No, we
fine.
can't.
It might be too low, so I'm going to try another type of sharing. Content from camera, window, not window, sound, isn't it? Right, something's going on. All right, it's a transcript. Okay. Bear with me. Not necessarily, I think. I'm trying to get window which has sound on it. Screen, maybe screen. For that, let me raise the, okay, it's on 100, fine. That's side by side. Include computer sound, there we are. All right. So this might help it. Okay, tell me now about sound.
Aim was to try and keep our global temperature rise below that.
Yes,
we can hear
now.
To do that, each signatory would set their own goals with a plan to reconvene every 5 years to ideally set more ambitious targets. And look, it was not perfect. Some critics at the time felt that it did not go far enough, but the key achievement was for the very first time getting virtually the entire world, including China and India, to commit to taking action. It was a historic moment, and it was celebrated like this.
The moment the world agreed to tackle climate change.
L'accord de Paris pour le climat est accepté.
And so the Paris Agreement was born, and emotions spilled over. So much so that Lawrence Fabius banged the gavel again.
So, I have been asked to bang the gavel again. It's a little gavel, but I think it can do great things.
Okay. Listen, I'll say this. If you are trying to convince people of the gravity of a moment, maybe don't use such a humiliatingly shitty gavel, because it just undercuts what you're trying to say. It would not be appropriate for a judge to conclude a death penalty case by saying, I hereby sentence you to hang by the neck until dead. May God have mercy upon your soul. Right? Solemn moment for everybody. So...
All right. So you got a taste of what it was like in 2015. What do you think? Let me have a few comments. I'd like to hear a few voices before I get back into a little bit more of the serious stuff. Paris Agreement. What are your feelings? Whoops. Anyone?
I'm not saying anything this time, just to let people talk, not only me.
Sorry? Anyone else? Any comments on? Oops, there's quite a few people coming in. Hello, guys. Is anyone listening?
Yep, yeah.
Yes, please. Yes, we can hear you.
Yeah.
Regarding the comment about the Paris Agreement, well, as it was said in the video, and as I personally consider, it is interesting that such a big number of countries have found the compromises and entered into an agreement. And even if this agreement is not particularly and practically can make all the purposes and aims that is described in this, but the commitment itself is great, because the more countries are involved and the more countries are trying to do something with climate problems and climate change problems. It is good for the solving for this purpose of solving these problems in general. Well, this is my point of view, that this agreement serves different purposes, and one of them is unison of countries in fighting with these problems. Yeah.
Yeah. Excellent. So that's the key point. It's not a problem that can be solved, you know, by country by country. It simply needs cooperation. So from that perspective, yeah, you got the main point.
Yeah,
excellent. So yeah.
I also think, of course, the agreement brought nearly almost the entire world under one roof just to deliberate on how to reduce green gas emissions, you know, and limit global warming in the entire world. However, I will beg to differ that, of course, you said it was a global perspective, not necessarily country level, but I think to measure the success of Paris Agreement depends on the success of what, or maybe, yeah, depend on the success of the implementation level and enforcement level or commitment made by each country. You cannot determine the success of Paris Agreement if you don't take into consideration how each country enforced or implemented the commitments that were agreed on this particular summit. So, as far as I'm concerned, the agreement was quite it was not so ambitious to effectively combat climate change, to be honest. But in natural sense, it was a step in the right direction, but needed more actions in order to achieve these objectives. It was good, but not sufficient enough to combat climate change, and needed more proactive ways of ensuring that countries commit themselves to the agreement that were made.
Excellent. Two different views. So let's see how the rest of today's lecture is going to help you each substantiate, using the provisions of the Paris Agreement, your arguments or your impressions. Okay, because there is material to support both of these views. One, that it is legally, it's a resounding success. Technically, you say that it's all about the implementation. So we can also see how there might be pathways for doing that, because we do need to have time. But remember, we're talking about a Paris Agreement that was formed in 2015, and we're talking about it in 2024. So that also puts a different perspective. The video that you saw there was from immediately after the 2015 agreement. So we have to go and see and ask the same people. You saw Al Gore in the front over there, recognizable figure. So if you can go and if you ask him now in 2024 what he thinks about whether his elation from 2015 is actually bearing fruit now. That might be his answer, may be perhaps not so happy. Right, so let's go back and I think my video sharing was a success. I'm going to try and use a few more of those later on. This was just a little test. All right. So the birth of the Paris Agreement, centrality of the Paris Agreement to UN climate regime. We need to unpick the first statement that I made, which is the treaty itself is a legally binding treaty. However, the provisions within the treaty are on a spectrum from being non-binding to being binding. Or we can look at it as different types of obligations. So obligations of conduct, to do something. It might only be to communicate, or obligations of targets, obligation of outcome. Okay, so there is a bindingness spectrum. Let's go into a few details of the bindingness spectrum. There's a lot more to the spectrum, but I've picked up 3 types of provisions you will see in the Paris Agreement. Firstly, provisions that create obligations. Secondly, provisions that generate expectations. And thirdly, provisions that recommend. This in sum is also how the managerial approach is being personified within the rules, international rules for addressing climate change. So provisions that create obligations. As you can see, there's 4 provisions that are very clearly worded to create obligations. If you want to read a treaty and decide on its bindingness, some words will help you do that quite clearly. The word shall is one such word. Okay, so that creates, you could go on to read to say that it creates obligations. Now, Article 4.2, Article 4.9, and Article 4.17. As you can see, this is all subsections of one article that is on Article 4. So if you were asked to pick just one article in the whole Paris Agreement, I would say you should pick Article 4. This Article 4 is on mitigation. 4.2, parties shall prepare, communicate, and maintain successive nationally determined contributions, in short, NDCs. They shall pursue domestic mitigation measures with the aim of achieving the NDC. So this is the highest contribution that the Paris Agreement has made. So the mechanism by which we address the climate change problem is the mechanism, the policy mechanism of NDC. Now, the parties have a clear obligation in Article 4.2 towards the writing, drafting of an NDC, and also for the domestic policy and law to implement the NDC. Article 4.9, the party shall communicate a nationally determined contribution every 5 years. 4.17, they shall be jointly responsible for its emission levels. So these are legally binding provisions within the Paris Agreement. Article 7.9, and this is on the second big topic in the Paris Agreement, which is adaptation. Article 7.9, parties shall engage in adaptation planning process and implementation of adaptation measures. Now, these obligations are worded for each individual party within the Paris Agreement. Now, you can go on and read provisions within the Paris Agreement and look at obligations that have been slapped collectively. Okay, so that's one genre of obligations that have been provided, and they are legally binding. Another genre of obligations is when the countries are divided according to the principle of differentiation, developed countries and developing countries. There are some obligations on developed countries towards mitigation. Okay, so that's another way of categorizing the legally binding obligation. What I have showed you in this slide is those obligations within the Paris Agreement that every individual party, irrespective of what category they might fall under, or collectively whatever they take to undertake to do, this is a legally binding obligation. Now, there are other provisions like Article 4.3. Now, this is also a mitigation provision, and this is something that generates expectations. So if you want to argue on effectiveness, you can read 4.2 and 4.3 together to say 4.2, brilliant. 4.3 should perhaps also have been in the same category as 4.2, which is creating obligations rather than creating expectations. So under 4.3, every successive nationally determined contributions that is being submitted by a party has to represent a progression beyond the party's then current NDC. So ratcheting up, or the ratchet mechanism. You wind something, it cannot go back in reverse. It can only progress forward. So it needs to be better and better. This is a mechanism we've borrowed from another area of law, which is international human rights law. So the progressive realization of rights, progressive realization of human rights is a concept that you find in international human rights law, which places an obligation, especially the second generation human rights, socioeconomic human rights. The obligation is that countries, according to the resources that they have, should never fall back in the implementation of socioeconomic rights. They have to keep moving forward. So it's not a mechanism that is unknown in international law, that has been used, and I would say quite successfully, probably with more success than in international human rights law. In climate change law, it's being used with more success. Then there are provisions that give recommendations. Article 7, this is an adaptation provision. 7.10. Adaptation should be as appropriate, parties should as appropriate submit and update periodically an adaptation communication. It's a bit similar to what we want to see in mitigation. And later on, you'll see in the reporting requirements that it could form an adaptation communication, could potentially form or be part of a nationally determined contribution document as well. Or it could be individual. That again depends on what sort of adaptation is being required within different regions of the world, within different countries. Article 13.8 is a recommendatory provision. Parties should provide information related to impacts as appropriate. Okay, so this will help other parties know about what the impacts are. So if there are heat waves, how has it actually panned out? We have modeling, but how did it actually occur when it did occur? So what sort of, how did the risks materialize and what impacts have they had? This kind of information is very useful for further planning. So again, that is part of the managerial approach. Okay, so Paris Agreement is a legally binding treaty, but the provisions within it have different levels of bindingness. And how do you find out to what extent it is legally binding? You look at the wording, you look at the context, you apply some of the usual rules that we apply within interpretation in law. You do a literal interpretation, you would do a purposive interpretation, you'll also do mischief, or what is the problem that particular article, or what is the issue that particular article is trying to address. So using all of these methods of understanding what the provisions are, we can also come to a conclusion about to what extent they are binding. So I'd recommend you to read the text further for a complete breakdown of the bindingness spectrum within the Paris Agreement. So, architecture. What is the approach we'll need to take within the Paris Agreement? Is it a bottom-up approach, or is it a top-down approach? Yeah. So in the family of the United Nations Framework Convention to address climate change, different legal instruments, we have examples of both the bottom-up approach as well as the top-down approach. Kyoto Protocol. The negotiations already said we are going to go for a top-down. We are going to dictate what measures states are going to take, and that's going to be done through the instrument that we're going to devise. And what ended up happening at that point, the negotiations actually led to the Kyoto Protocol itself, which is another treaty within the framework of UNFCCC. In the run-up to the Paris Agreement, the COP that took place in Durban in 2013 came up with the final document, which was called the Durban Platform. So the Durban Platform did not provide any specific direction, whether it will be top-down or whether it will be bottom-up. So there were some parties which wanted a top-down approach. There were other parties which wanted more autonomy. So they wanted a bottom-up approach to be adopted for the final shape or the final legal instrument that would come out from Paris COP. Some examples of bottom-up instruments within the UNFCCC. The decisions taken, Copenhagen Accord is a decision that was taken in a COP, in the Copenhagen COP. Cancun agreements, all of these more bottom-up. They're not legally binding, but they have a lot of direction, and they have helped evolve the rules that have eventually now become Paris Agreement. But those accords themselves, or those instruments themselves, allow the parties to do whatever form or shape that they want to address the climate change problem at that point in time. Okay. So what did we then finally agree? We have the 2013 meeting of the parties did not specifically lay down a particular architecture for the negotiations at the Paris COP. So we finally went for a hybrid approach. Okay, you might think, oh, hybrid means neither here nor there, but no. What it really means is that it's a fusion of both the top-down as well as the bottom-up approaches. Now, this started becoming visible even in the COP that preceded the Paris COP, which was the COP in Warsaw. Okay. Poland, by the way, seems to be the country that has hosted the maximum number of COPs. There was a COP, so the Warsaw COP was preceded by the COP in Poznan. And they also had another COP, 2018, I think, if I recollect correctly. That was in Katowice, also in Poland. So it seems to have the distinction of hosting COPs. So the Warsaw COP came up with this idea of INDC. Yeah. So when you read the literature, you will find NDCs mentioned. You'll also find INDCs. When you do find that, don't get confused. The origins of that are in the negotiating documents, particularly from Warsaw COP. So what they wanted to look at is in 2 years' time, because the negotiations had already been set up for a new approach and a new instrument within UNFCCC. So they started looking at what is it that countries can actually do if you want all countries to join. Okay, it's not just the Kyoto Protocol annex countries for mitigation. If you wanted all countries to join and to say this is what we can do to reduce greenhouse gas emissions, what will that contribution look like? Yeah. So they were asking for what is your intention to do? What in your planning, in your national planning, now that you know this problem is looming, this problem has already even shown its impacts, and you all being part of the UNFCCC, how would you like to do it? Okay, so calling for every country. They were asked to submit the intended nationally determined contribution. This is a bottom-up process, each party able to define various things, stringency. Okay, how hard are they going to be on themselves? Essentially, how much politically the ruling government at that time can get away with laying these restrictive conditions, because mitigation means, while there are opportunities, but it mainly means you need to cut down on emissions, which means you need to cut down on your industrial policies or change direction, which always has more costs as well as, you know, more difficulty in getting agreement across the board. So how stringent do you want to be? What is the scope and what is the form of the contribution that you intend to make? So INDCs were a mechanism created in Warsaw. Then we had a top-down process. The top-down process that was decided to be incorporated into the Paris Agreement. Parties have to communicate in a manner that facilitates clarity, transparency, and understanding. Okay. So parties have to communicate. This is a unified top-down approach. They have to very clearly say what it is that they can't fudge. They will be asked questions. Okay. They will have to declare in a certain format what it is that they intend to do. They have to disclose. They have to be transparent. And what they are doing, every other party should be able to understand how it contributes to reducing the problem, right? So bottom up, countries are allowed to decide in terms of what they were going to contribute and what the scope of that will be, but top down, they needed to provide details. That means even through this procedural aspect of communication, you were asked to think about aspects that you might otherwise wanted to have bypassed or fudged, okay? And there's also another advantage in this obligation for communication is that you can then name and shame, saying, look, you are the countries who haven't actually fulfilled this. Now, that does have a powerful impact. Then there was COP20, just the one before Paris, which was COP21. Which took place in Peru in Lima, Lima in Peru. Information that states may provide in their NDCs. So there was more of a central direction about what sort of information that states will have to provide in their eventually NDCs, but in that lineup, it'll be the INDC. Okay, so it was becoming more and more harmonized as to the depth and the type of information, which means indirectly it also stimulated action about, you know, deeper decarbonization, deeper or more effective mitigation efforts. Assumptions. So in that information, you have to give what are your assumptions, what might your policy pathways be, where will they lead to? You have to be accurate, you have to be detailed, you have to talk about how you measure those methodological approaches, the timeframes within which you will achieve these. It's not just enough to have a long-term 2050, 60, 70. You do need to quantify even before that. Scope, coverage. So it gave a lot more direction in terms of, you know, what all every country needs to. Again, strengthening that top-down approach in this aspect. And it also said, you can't take inordinate amounts of time, so you submit your INDC in the first quarter of 2015 in time for the Paris Agreement that would be taking place as part of the Conference of Parties towards the end of the year, because then between the first quarter and the end of the year, there's enough time to do an informal review, an ex-ante review of the INDC. So apart from the fact that there was no penalty for all of the, you know, if a nation submitted plans that are not effective towards reducing GHG, everything else was in place, you know, a review from someone external, countries giving their detailed plans, etc. So this was how the architecture of the Paris Agreement was set up by COPs, the two COPs that were preceding it, which was the Polish one and the Peru COP. And in Paris COP, there was bottom up as a summary, bottom up for participation, and top down for ambition and accountability. But I have to qualify that by saying that the transparency, accounting, and updating process was the part of ambition and accountability, not anything more. So if you are minded to criticize what Paris Agreement achieves, this is another point that you could use to say, well, yes, that ambition was top down. The accountability for it also was top down, because the to get countries that haven't contributed as much to global emissions historically to agree to also consider mitigation. All right, so that's why participation is valuable. Okay, scope. What are the topics and the themes that are being covered by the Paris Agreement? What are the exclusions? What are the inclusions? So by now you can guess the COPs get involved in scoping agreements and future action. So in terms of scoping what topics was required for the new instrument under UNFCCC, the Durban platform. The Durban COP in 2011 set out the themes: mitigation, adaptation, finance, technology development and technology transfer, transparency of action, support, capacity building. And in previous COPs, in Bali, in Indonesia, where the final document there was called the Bali Action Plan, that focused on adaptation, finance, technology development. Now, when you think of scope, you could add a lot of things. But the key is, how do you get an agreement that is not so unwieldy? You cannot keep adding many, many, many things within the scope. So you're going to have to prioritize and pick. Now, the reason why the 2011 and 2007 final documents are being indicated here is because the emphasis is different. In 2011, you can see there is an emphasis equally on mitigation adaptation. And everything else sort of, revolves around those two. But in Bali, you can see the glaring gap of mitigation. So the emphasis there was on adaptation, finance, technology development. So adaptation was really the key theme. The others were attendant to adaptation. So now you can see where the different lines are being drawn for what needs to be covered under this new treaty. How are these lines drawn? There are groupings that negotiate for different positions. The US, the ILAC. This is another grouping of states, Independent Association of Latin American and Caribbean countries. Australia, these three sets of interests were emphasizing on the points placed in Durban platform, right? So mitigation, adaptation. Now, India and China, Not the only ones, but definitely the really big prominent ones. The Bali Action Plan was being emphasized. One of the fears of India and China was that if there was an emphasis on mitigation and everybody was participating in it, that means their growth and their development plans will have to be radically changed or affected. Perhaps it's going to be more costly to be able to grow in the same way, or perhaps it might not even be able to grow in that same way. Okay, so by emphasizing an adaptation, they also then increase the chances of development as well, right? Because the growth is also affected by disasters. So that might be the thinking, or that is the thinking behind the countries who want to emphasize more on adaptation. Those that see that they need to grow more, those that see that needs to make sure that their interests, their national interests are protected. African group, LDCs, ILAC, they also were looking at a parity in the political treatment of mitigation and adaptation. So a slightly different way of looking at this, as in we need to give mitigation and adaptation the focus. Okay, and they have to be equal focus. There needs to be equal time dedicated by the negotiating parties on both of them. Now, that is also a slightly different approach to how it's happened in previous COPs. So each of them scoping out the instrument in slightly different ways of emphasis, or not even slightly. Their positions definitely are quite different, but what eventually happened was that we had mitigation as well as adaptation stand out extensively. And we'll see that being reflected in the provisions of the Paris Agreement. Okay, so that is scope. And here are the provisions of the Paris Agreement, or the key provisions of the Paris Agreement. You can divide them into these big themes: mitigation, market-based approaches, adaptation, as well as loss and damage, support for these activities, and then oversight. Okay, so these are the big themes, big ticket themes that eventually found its place within the 2015 Paris Agreement. We look at Article 4 and look at all of its provisions to consider what the obligations of states are, what the recommendations of states are with respect to mitigation. Article 6, how does the market-based approach figure? In fact, it doesn't. Non-market-based approaches figure as a concept within Article 6. But we'll see what sort of mechanisms are being recommended in Article 6 with respect to carbon trading, etc. Adaptation, loss and damage. Article 7 on adaptation, loss and damage in Article 8. And then support, technical support, technology transfer support, capacity building support. So these are all in Article 9, 10, and 11. And then Articles 13, 14, and 15, in terms of oversight, have Articles 4, 6, 7, 8, 9, 10, 11 functioned or being implemented in the way it should be? So who's responsible for that? What mechanisms are in place for oversight? Yeah. So the general design of the treaty is very much like a lot of other international treaties, of course. So you've got what the problem it's trying to address is, what sort of institutional mechanisms there are, and then how is the treaty itself going to be implemented, right? So nothing too different there. So before we dive into the provisions, some food for thought about the preamble. Okay, the preamble is the least binding of all the provisions within a treaty. Yeah, but the preamble very much sets the context of how we have to understand the words and the phrases within the articles in a treaty. Yeah. So in a recent decision by the Human Rights Committee for a case that involves small island countries, Torres Straits Islanders petition, it was laid out that treaties should be interpreted in the context of their normative environments, right? Now, this is not new. It is a restatement of the principles in the Vienna Convention on Law of Treaty, Article 31, which talks about the context within which the treaty, any treaty, has been put into place, needs to be taken into account to interpret the meaning of the provisions of that article. So, in order that you don't just keep listening to my voice, I've got one more video, which is talking to you about the specific context for the UNFCCC treaties. So let me see if I can share my screen on that. I have queued it to the right place, so it should start in the middle of that lecture. Is it this? Not that one. That one there, okay. Share, share. All right. Tell me if you're able to hear me. Hear the video, all right? This I can increase the volume.
And the object and purpose. At least part of the context is the science.
This is fine.
And
yeah, okay.
Yes.
Excellent.
But if you press F11, we'll see the full screen.
Oh, you mean like that?
Yes. Yes.
All right.
Thank you.
Yeah.
Perfect.
Perfect.
And this has been repeatedly endorsed by states in the context of the Paris Agreement and in subsequent COP decisions. The Paris Agreement itself says the state's response to climate change must be guided by the best available science. And the best available science is the IPCC's latest report, AR6, which says that deep, rapid, and sustained reductions in greenhouse gas emissions are necessary. It's worth keeping in mind that the summary for policymakers from the Intergovernmental Panel on Climate Change is actually negotiated line by states. So it is consensus. It is not, it represents not just consensus science, it also represents political consensus. It is negotiated just as hard as the COP decisions and as Paris Agreement was negotiated. Best available science, especially the summary for policymakers, the IPCC's AR6, deep, rapid, and sustained reductions is very much part of the normative context and the environment within which the Paris Agreement has to be interpreted. The object and purpose.
Okay. It is part of a longer video. I don't want to play it on over here. The reason I played that particular video is because the person presenting there is one of the 3 authors of the climate change textbook I have recommended to you. She happens to be an Indian environmental lawyer who's a professor at Oxford, L. Rajamani, and she gave this lecture just about 3 days ago over here. So I thought it would be something that you can listen to in full. So I will send that along in the reading list when I eventually come around to doing that reading list, right? So the message that she was talking about over there was the contextual environment. What was the contextual environment? She said AR6. We will eventually be introduced to the reports that are produced by the Intergovernmental Panel on Climate Change, the IPCC, which is a key institution which is relevant to the Paris Agreement and the UNFCCC in that they set the normative environment. From a legal perspective, we call scientific knowledge on climate change the normative environment within which it needs to be, within which we need to understand the provisions of the UNFCCC. Okay, so she was going to go on to say that one is the IPCC reports. The IPCC has just produced its 6th cycle, okay, of reports. So we need to take into account lots of other cycles. She also was saying that the IPCC it's the intergovernmental panel, but it's independent and they go through a process of negotiations as well, whereby there'll be some scientists that'll be disagreeing to other scientists. So they have to then go back, look at their methods, and then come and say, well, okay, if this is where this is how we measure how global temperature has risen, maybe this is how we need to also look at adjusting it because of these reasons. So there's a lot of negotiations that take place in the background, the scientific background. The science just doesn't come to us because it's been picked up by a set of policymakers. Okay, so this is the only international area in law which has the benefit of this much of scientific knowledge being processed and channeled through into the provisions of a legal treaty. Okay, so with that slightly different voice, we can now come back to my voice again. And let me share my screen. All right, there we are. So the snippet that you heard from Professor Rajamani was on this YouTube link from 22 minutes, 36 seconds onwards. So what do we find in the preamble of the Paris Agreement? I'm not going to, cut and paste the preamble here, but there'll be keywords that'll help you form a picture of what are the issues being identified as very important for which the rules are being formed in this treaty. CDBRRC. I deliberately put it as an acronym. Can anyone guess what this acronym might be? It's a principle. It's a principle that's central to UNFCCC. Any guesses? Okay, once I say it now, you have to remember it afterwards. Common but differentiated responsibilities and respective capabilities. Okay, common but differentiated responsibilities and respective capabilities. Best available scientific knowledge. Special circumstances, particularly vulnerable states. Special needs of LDCs or least developed countries. So these are all featuring as, it's not featuring as bullet points, it's featuring in the narrative of the provisions of the preamble. So you need to keep, so this particular agreement is cognizant of this principle of common but differentiated responsibilities. Paris Agreement will always work on the best available scientific knowledge, will take into account the parties to this treaty, will take into account the special circumstances, particularly of vulnerable states. Now, in international law, we are quite familiar with developing countries, least developed countries, developed countries, etc. But now within climate change law, we are getting another category of countries which have special circumstances created by global warming, that is, countries that are particularly vulnerable. Okay, so a new category of international law grouping of countries. Equitable access to sustainable development and eradication of poverty. You've heard about sustainable development before, but note this is a specific reference not to sustainable development, but equitable access to sustainable development and eradication of poverty. What do we mean by that? Equitable access. I don't need sustainable development in 50 years' time. If some countries are developing now, I need to develop now as well. Because isn't that what has happened before? A lot of countries have developed at the expense of certain countries much earlier. That is who are developed countries, yeah? But when we say equitable access to sustainable development, any new opportunities that comes because of climate change has to be equally distributed to all of the countries requiring sustainable development. Let us say if we pick up Bangladesh, okay, they are a least developed country. That means they have to have more access to climate opportunities because that's the way in which they can become equally sustainably developed. But if we say there's UK over here, there's Bangladesh here, let's give both of them equal access. No, UK has to have less access, Bangladesh more access, because that is what is equitable. Okay, so equitable access to sustainable development and eradication of poverty. Eradication of poverty, you may be aware of the Sustainable Development Goals. Goal number 1 is eradication of extreme poverty. Okay, now eradication of poverty over here is not the same as eradication of extreme poverty. This is a bar that is a bit more higher. Okay, so it's not just extreme poverty, but because there are opportunities, there's opportunities for growth in because you take measures under the Paris Agreement, you can eradicate poverty in a way that goes beyond the eradication of extreme poverty. Food security. I mentioned that for the first time in Dubai UAE consensus, we had food security or crop protection come up in the context of COP, in the context of UNFCCC. But you see them being previously mentioned in the preamble here. Just transition of the workforce, another theme. Conservation and enhancement of sinks, carbon sinks, that's what it is. And I can talk a lot and we can discuss a lot on all the topics of preamble, but we might just move away from discussing the provisions. So I'm just throwing you these, which you can pick up. Ecosystem integrity, climate justice, environmental education, awareness, training, and participation. Some of these things are new. Some of these are what have carried on from previous, and they're taking into account that needs to happen in a continuous manner. Multi-level governance. Governance at the local level, at the subnational level, governance at the national level, governance at the regional level, governance at the global level, multi-level governance. And there needs to be a connection between all of the levels. Sustainable patterns of consumption and production. Oops, someone put their thing on. Right, sustainable patterns of consumption and production. So now we start looking at, hey, are you allowed to drive your diesel vehicle? Okay, who's consuming? The consumption comes directly from individuals, okay? Companies and governments don't consume. The people working in companies, the products from companies to people are the ones that do the consumption. So you start now, the climate change treaty, I'm not saying it places any obligation on an individual, but what I'm saying is in the preamble, they start looking at individuals as well. And then there's also a mention of human rights. Now, the mention of human rights was hotly contested in the negotiations in the run-up to the Paris Agreement. How do you find the mention of human rights in Paris Agreement? That's what you have to carefully look at. There is no all-out mention of human rights. What is mentioned is only equality clause, okay? What is mentioned is only non-discrimination, i.e., you have to consider everyone equally. So, for example, a mitigation measure that is put in place must be in a way that it doesn't discriminate against, one person against another or one group against another. So if you take, for example, as disabled people as a group, any mitigation measure that you put in place should not put them in a position such that they are more disadvantaged than everybody else, okay? Or, for example, a mitigation measure that you put in place should not unduly affect women as against men. So the only clause that you find with relation to human rights is the non-discrimination clause. But we already know, okay? When we say we already know, I don't mean legally. What I mean is there are a lot of arguments about climate change affecting human rights, meaning climate change affects the right to life. Yes, if you have a forest fire and if someone dies in it, it is because so the right to life was being taken away by the forest fire, which is a direct effect of climate change. Right to health, clean air, lots of pollution, lots of lung disease or a lot of pollution-related disease. And that is a well-documented phenomenon. Food, like we said, there are high food prices. There is a lot of scarcity and shortage, and also inability to be able to produce food. So all that affects the right to food. Housing, how many places have been destroyed, and the houses have been destroyed because of hurricanes, which are said to be intensified because of the effect of climate change. So all of these rights, which are human rights, are affected by climate change. However, human rights is not counted in the Paris Agreement in determining the scope, ambition, and scale of mitigation or adaptation action. Okay, they're not saying you have to increase mitigation because climate change threatens a right to life. You might think that's pretty obvious, but legally it is not at all obvious. Well, why? This is a separate discussion to go into, but for the those of you listening into this who are studying international human rights law or who are familiar with the rules in international human rights law, we know that human rights are divided. They're all not equally considered. Yeah. So civil and political rights are enforced very differently to socioeconomic rights. And then cultural rights are not enforced even as much as socioeconomic rights. When you look at health, food, housing, they're all socioeconomic rights. So that means the obligations, human rights obligations of states for the fulfillment of these rights are not already strong enough. So you can see the legal reason why they don't feature in the same way over here. In a later lecture, when I look at climate change litigation, we'll see that there are a lot of cases coming around just this area. So there are some claims around the right to a healthy environment, which is not a human right, by the way, now, but there is a huge call that we should have that human right to a healthy environment. So there's litigation around that. Then there's litigation around all of this, that human right to health and climate change is being affected. So there's a lot of, and even that case that I've mentioned, the Torres Islander petition that came up before Human Rights Committee. Again, it's a Human Rights Committee, so they sit to adjudicate on the conventions on civil, political, socio-economic human rights. And that was also, so we'll pick this up later on. So that was a snapshot of the key terms featured in the preamble. Right, what's the time like? Should we have a break right now and then move on? What's the time?
Yeah.
7:30.
7:31, yeah.
7:31. All right, okay. Oh, it's not a bad timing. So let's do that. So let's get back here in 10 minutes time.
Okay.
Yeah, see you guys in a bit. Is it time? Yeah. It is.
Yep, we're back.
Back. Right. Rightio. Let me share. Right. Well, Article 4. It's not like a blank in the treaty. Let's see the various provisions of Article 4. It's a very long provision in the treaty. 4.1. Parties aim to reach global peaking of greenhouse gases as soon as possible. I've taken key sentences, key phrases, okay, so they may not always be the complete picture, but it gives you the skeleton definitely of the articles, but also a lot of flesh on the skeletons too. But for the full deal, you do need to read the whole document, right? So what is global peaking of greenhouse gases, greenhouse gas emissions? So in the first to the second class, I showed you the cat thermometer, right? Which showed you how the temperature, the global average temperature is actually rising. Well, here you see in 4.1, there is a license to do just exactly that. What they're saying is, or what parties agreed, is that the emissions, the greenhouse gas emissions are actually going to rise, okay? But there will be a point that you can consider is the maximum emission. So that's what is called the peak, okay? The summit, the top of what is possible. So what they're saying is get to what is your maximum use as soon as you can, because you're going to have to come back down. So global peaking of greenhouse gas emissions as soon as possible, 4.1. 4.1 is the mitigation article, yeah. Prepare, communicate, maintain successive nationally determined contributions. So you need to do a first one, nationally determined contribution, then you have to do regularly similar NDCs. So you have to, not only do you have to prepare them, you have to also communicate them. It's not enough if a country just holds it within their repository. It should be communicated. It should also be made public. We'll also see that in the provisions later. Successive nationally determined contributions will represent a progression beyond the party's then current nationally determined contribution and reflect its highest possible ambition. So that's the third condition that's being laid down. You have to give an NDC, you have to give NDCs on a regular basis, and each of them should also not be lesser than the previous, but each of them should also be the highest possible ambition that you can actually have. So each thing is a slightly different condition, okay? So pay attention or understand these words discreetly and distinctly. Developed country parties should continue taking the lead by undertaking economy-wide absolute emission reductions targets. So this is for developed countries. Note the phrase economy-wide absolute emission targets. Economy-wide, meaning every sector: agriculture, forestry, transport, aviation, shipping, every sector, okay? It's economy-wide. But what about developing countries? They should move towards economy-wide, okay? So if you think of examples like the coal, coal mining in India, coal in China, they could take mitigation efforts in other areas, like bringing in renewable energy, but they might decide that they are going to extend their coal. Or in other countries' examples, you can think about they might want to extend their use of oil. So that wouldn't then be an economy-wide. Right. So developing countries should move towards economy-wide, and developed countries should continue to take the lead by undertaking economy-wide. So you can see the principle of differentiation playing a role over here. And also there is the common and differentiated responsibility. So both developed and developing countries have the common responsibility of mitigation of emissions, but they have a different type of responsibility. That's what common and differentiated means. So in this case, one of them has to take an economy-wide approach to mitigation, and another set of countries have to take, it could be sectoral, but not necessarily across economy-wide. But eventually, the idea is they also move towards economy-wide, okay? Because that is the scale of the problem. 4.5, support should be provided to developing countries for the implementation of this article. The support, when we come to the provisions on support, we will look at the different types of support that may be needed. The least developed countries and small island developing states may prepare and communicate strategies. Yeah, so they too, it's really all hands on deck. Okay, so even the least developed countries and small island developing states should also consider Article 4. So this embodies the idea that all the countries are participating in all of the efforts under the Paris Agreement. Mitigation co-benefits resulting from parties' adaptation actions or economic diversification plans can contribute to mitigation outcomes. This is a slightly more technical point, meaning what do you count as mitigation? What do you count as adaptation? There could be mitigation co-benefits that come from adaptation action or economic. Like, for example, if you say renewable energy, you are doing that for a purpose. It is primarily mitigation, but there may be some examples where it is an adaptive action. It depends on the type of energy that you're using, etc. All parties should provide the information necessary for clarity, transparency, and understanding. So anything to do with mitigation, other parties should know what you as a party is taking action. So you need to clearly lay it out. It needs to be transparent. It needs to also be other parties should be able to agree with you that this is for the purpose of fulfilling the main aim of containing global warming. 4.9, each party shall communicate a nationally determined contribution every 5 years. Okay, every 5 years. Conference of Parties, serving as the meeting of parties to the agreement, should consider common timeframes for nationally determined contributions at its first session. So in 2015, they said, right, let's start. The clock is ticking now. So every 5 years we need to do it. So we had the, you have to look at when the treaty was adopted, 2016. And when the first set of our NDCs were submitted, then you have enhanced nationally determined contributions also being submitted. And that was what we looked at during the global stock take, which is going to come very soon. As in the relevant provision for that is going to appear soon. 4.11, a party may at any time adjust its existing nationally determined contribution with a view to enhancing its level of ambition. So there's no problem in revising it any number of times, but it should be revised upwards, not downwards. NDC communicated with parties will be recorded in a public registry maintained by the Secretariat. So it's not just for the record in the Secretariat. It is a public registry that we can all view. Okay, so if it's public registry, you and I can actually go see it. So every country's NDCs so far you'll be able to do, and you'll also be able to look at the ENDCs, so the enhanced NDCs as well. 4.13, parties should promote environment integrity, transparency, accuracy, completeness, comparability, and consistency, and ensure the avoidance of double counting, right? So the auditing aspects should all be very, very good. And this is a whole big industry in itself. Okay, and this involves lots of accounting, lots of field work, lots of calibration, etc. So, and as lawyers, you should be able to read and understand the content of these documents, because only then you can actually say, well, it's been in compliance with the treaty provisions. So technical understanding or development of some technical understanding around how emissions are counted, how emissions reductions measures are devised and designed, etc., is necessary. 4.14, when recognizing and implementing mitigation actions with respect to anthropogenic emissions and removals, parties should take into account as appropriate existing methods and guidance under the convention. This is also a testimony of the top-down approach, right? Trying to get as much as harmonization in mitigation action between the parties through these provisions. 4.15, you have to take into account the economies most affected by the impacts of response measures. Now, mitigation is a huge transformation to industrial policy and thereby to the economies of countries. Yeah, the effects of all of these measures are not necessarily known because of the scale of the measures. Okay, so while these measures are being implemented, you have to take into concerns the impacts of the response measures. So to some extent, we can look at this as saying, okay, how does it positively or negatively impact human rights? That's just one way of measuring it. Okay, but there's so many other ways and so many other angles from which it can be measured, not necessarily the framework of human rights. It could be non-legal frameworks. And the article still goes on. 4.16. Parties that have reached an agreement to act jointly under paragraph 2 of this article shall notify the Secretary of the terms of the agreement. So cooperation is valued. So it could be because you are part of an economic integrated zone like the European Union. The European Union makes its laws in a manner that it applies to all of its member states. Yeah, so it's a regional integration organization. It could be because you work jointly under such an arrangement, or you could work jointly out of that arrangement, and not so strongly, but more loosely as well. But if an agreement is reached for parties to act jointly, then they have to be notified. Each party to such an agreement should be responsible for its emission levels as set out in the agreement, right? So each party should still be clear about what its share of emissions reduction is. And then 1.8, each member state of that regional economic integration organization individually and together with the organization shall be responsible for its emission level as set out in the agreement communicated under paragraph 16 of this article. Again, it applies to EU as an example, and the irresponsibility is basically it's not joint and several, meaning if one country slips back, then the other countries take the slack. But if it is done that way, it needs to be attributed to this to the country that is not taking enough measures. Yeah, so you cannot. Each country is individually responsible, even if it agrees to work jointly. Okay. All parties should strive to formulate and communicate long-term low greenhouse gas emission development strategies, mindful of the principle of differentiation. So this is another interesting set of documents that you can find on the website. So this is shortened as LTLEDS, or long-term low greenhouse gas emissions development strategies. So this is about growth, okay? So this is about development, and this is for all the countries. So they're talking about not the 5-yearly, the stock take of what mitigation, that is specifically around mitigation. But 4.19 gives us an opportunity to look at the specific nationally determined contribution towards emissions reduction and to compare that with what are the long-term development strategies of the country. It'll be good, or it's good practice to be able to have long-term development strategies that are greenhouse gas light, but there may be necessities of the countries to develop while not being able to cut down emissions. So this whole concept of unavoidable emissions is all built in there as well. So there may be countries that might, you know, for the purpose of stainless steel making, still operate some coal, some factories that rely on coal, right? So this might be because they do need that for their economic strategy, for their growth strategies. So this is a different document to NDCs, but having both these documents together, we'd be able to assess to what extent the success of the NDCs is set into the economic trajectory of the countries. Right, so that was the mitigation provision. The next provision we're going to look at is the market-based approaches, okay? Now, the reason why I just put this as one big block is because the market-based approaches at the moment is not fully functional. There is no particular market-based approach. When we say market-based approach, it is about trading in carbon credits. So it's all around the concept of, if I'm not able to reduce my emissions, there might be another country that can reduce its emissions quite a lot. So what I do is I buy credits from that other country. So under the Kyoto Protocol, market mechanisms were functional. So the European Union's emissions trading system, EU ETS, is one such example. And it's the most successful example. It's not taken off in other areas, okay? And that is also reflected by the fact that Article 6 is a bit lukewarm and slow in sort of taking off. Yes, countries are negotiating around it, but we haven't actually seen. So quickly, what does Article 6 actually say? While I was talking, you might have even read this, if you can multitask well, but otherwise I'll take you through the provision. 6.1, parties recognize that some parties choose to pursue voluntary cooperation in the implementation of their nationally determined contribution. Okay, so that's what I meant when I gave you the example of saying one country has high emissions, another country has low emissions and the capacity to reduce it even further. Then they cooperate on a voluntary basis so that in order for one country to implement its nationally determined contributions, then it says that I am offsetting my emissions by investing in reductions elsewhere. Parties shall, where engaging on a voluntary basis, use internationally transferred mitigation outcomes. Yeah, so it can be outside your region as well, towards promoting nationally determined contributions. So United States, for example, could say we have excessive emissions. In order to reduce it, we can't reduce it within our territory, so we will fund a forest or vast swathes of forests in Mexico, which can act as carbon sinks and thereby we will fund it to make sure that the forest is kept as a forest, or maybe new forests are grown over there. And that's the way in which internationally transferred mitigation outcomes can be counted towards nationally determined contributions. They should promote sustainable development, meaning, you know, you don't go to Mexico and take up all their food producing farms and turn them into forests because it'll give you carbon credits, right? There are some problems around these approaches, especially these issues around carbon forestry. So it should promote sustainable development. It should ensure environmental integrity and transparency. It should include robust accounting. Don't do double counting. In short, outside of legal terminology, we have this term called greenwashing. Yeah, so don't greenwash. But you can notice I didn't put Article 6.2 as a legally binding provision when I first laid out obligations. Okay, so to that extent, you might say that these provisions are weak. And you might also say, when you read literature, this greenwashing came about because we don't actually ask the parties to very clearly produce produce documents towards their accountability in these provisions, which is sustainable development, environment integrity, transparency, etc. A huge, big issue with the carbon trading system. The use of internationally transferred mitigation outcomes to achieve nationally determined shall be voluntary and authorized by the participating parties. Yeah, because the emitters are not always government organizations. So they're not really connected to the parties legally in the same way as if the party itself or the government itself will have to reduce on its estate, for example, the amount of emissions it uses. So there will be, they can be private organizations, they're corporate bodies. So that means there needs to be some sort of oversight. So authorization by the governments for the actions that are taken by organizations to do these international mitigation efforts. A mechanism to contribute to the mitigation of greenhouse gas emissions and support sustainable development is hereby established. So 6.4 basically gives the power for the parties to establish the mechanism. Okay, it's not, so a global emission trading system has not yet been created. The power to it is found in 6.4, but the outcome is yet to become. Emissions reduction resulting from the mechanism referred to in the above paragraph 4 shall not be used to demonstrate achievement of the host party's nationally determined contribution. Okay, if used by another party. So again, it's about double counting. Conference of parties serving as a meeting of parties. So the COP is where they will take all the decisions, and it can also decide that any kind of new mechanism that is set up, the cost for that will be taken out from the administrative cost of that is taken out from any proceeds that come from managing this international emissions trading system. Conference of parties serving as they shall adopt the rules, modalities, procedures. So these provisions are all about a institution setting within the Paris Agreement for the purpose of international trading. Parties recognize the importance of integrated, holistic, and balanced non-market approaches. Okay, so this whole of emissions trading is all built around the free market principle. It's the price of carbon. Okay, and one of the problems with this is that the price of carbon is currently too low in most of the carbon markets that we see around the world. Right, so that means the cost of the efforts to reduce emissions is actually way more than what is reflected in the carbon price. Right, so there is there are two opinions on this. One is that carbon markets are simply necessary as part of our mitigation efforts. The free market principle simply has to work. But the extent to which carbon markets play a role in mitigation is a big question mark. From what I see, apart from the EU ETS, there are not many successes anywhere else. So 6.8 then recognizes. So if you notice in all of the subsections of Article 6, you don't actually find a reference to market-based approach, whereas in 6.8, you actually find a reference to non-market-based approach, okay? So it's not particularly saying what approach, but it's saying it should not be market-based, right? So it is recognizing the importance of much more integrated, holistic, and balanced non-market approaches. And what do we mean by non-market approaches? Well, we're talking about industrial policy and how industrial policies are about regulating industries. So you could basically say this industry can only have this much a quota of emissions that it can have. So you can't go above this emission. All your business processes, all your products, everything have to only be resulting in this many emissions. You can't say I can expand my production and then for any extra emissions I will offset it off by trading it. So that's one way of saying it needs to, carbon markets have a place, but they have to be along with non-market approaches, which are developed. So that's 6.8. 6.9, a framework for non-market approaches to sustainable development is hereby defined to promote the non-market approach. Again, the non-market approach, the power to develop that is in 6.9, but it's not been developed within the Paris Agreement per se. I mean, that doesn't mean that there aren't any non-market approaches being undertaken in countries, but there's no concerted effort to produce a framework at the international level. Right, that is Article 6 done. Article 7. Does anybody remember what Article 7 is about? Let's see how many of you are actually listening to me, or how many have you just nodded off?
A global goal on adaptation of enhancing adaptive capacity, etc. I'm listening to you, definitely.
Excellent. You're allowed to have dinner as well. That is fine. You can multitask, dinner and meat, but then you have to listen. Excellent. So Article 7 is about adaptation. It's another marathon article, lots of different provisions. While I read through the Article 7, bear in mind how it compares to the wording and the obligation under Article 4, which was on mitigation. 7.1, parties hereby establish the global goal on adaptation of enhancing adaptive capacity, strengthening resilience, and reducing vulnerability. So we now have a meaning for the term adaptation within the Paris Agreement. Adaptive capacity, resilience, reducing vulnerability, huge big terms and concepts in themselves, okay? But the scope of adaptation is now laid out in 7.1. Recognize adaptation is a global challenge faced by all local, subnational, national, regional, international dimensions. So the scale of adaptation is completely determined. So you can't say, right, I live in the polar regions, so therefore I don't need to, I live in the equator, so I don't need to adapt, okay? Or that I don't have wildfires in my backyard, or wildfires are not an issue over here. So the idea is that the notion of adaptation, whether it is now or in the future, it's imminent or even already happened, it's a global challenge. Yeah. Why? Because the world is globalized and the impacts can be felt in various ways. I physically might not feel the impact, whereas I did physically feel the impact when there was a tsunami back in India that many years ago now. Okay, so there's the only way in which you can now think about the problem of adaptation is if you look at it as a global challenge. If every party looks at it as a global challenge, yeah, not just the small island nations. Adaptation efforts of developing countries shall be recognized in accordance with the modalities to be adapted. So you might be wondering, well, what's the point of recognition? But it has its advantages in that where is the money being spent in a country? Yeah, depending on how much you need to adapt to, you need resources, you need technology, you need support. So only if you recognize a particular action as having been conducted in the context of its adaptation, will it be then fed into in various ways within the mitigation and the rest of the provisions of addressing climate change. Parties recognize the current need of adaptation is significant, and greater levels of mitigation can reduce the need for additional adaptation efforts. And that greater adaptation needs can involve greater costs. So 2 points made over here. This connection between mitigation and adaptation. It's possible that if you do greater mitigation, you will have lesser need for adaptation, or the ways in which adaptation needs to be done could be different. And secondly, as you go forward, the adaptation costs will be greater, right? Unfortunately, that's what we need to recognize. Why? Again, we have the background to this. We noticed on our CAT thermometer that the global average temperature is still rising, and potentially, even with all the mitigation efforts right now, the global average temperature could go up to 2.7, right? We're making an effort to bring it down. So given these two facts, we can with certainty say that adaptation costs and needs will only go greater, and also that the extent to which it goes greater or lesser will depend on whether our mitigation efforts are greater. So we have to do both. 7.5, this is how adaptation action should be taken, right? It should be country driven. So I can't tell Egypt how adaptation looks like in Egypt or how adaptation should be done there. It should come within, driven by the country, but it doesn't mean I shouldn't cooperate. In fact, I have a positive duty to cooperate, right? So it should be country driven, it should be gender responsive. So there's a very clear provision here of non-discrimination. Participatory, so all levels of governance, multi-governance. Fully transparent approach, take into consideration vulnerable groups, communities and ecosystems. So it's not just people, it's also about earth systems, ecosystems. It doesn't mention earth system. I wish it had, but it's only talking about ecosystems, because ecosystems are smaller, let's say, than earth systems. Should be based on best available science, okay, and as appropriate, traditional knowledge, knowledge of indigenous people, local knowledge systems, with a view of integrating adaptation into relevant socioeconomic environmental policies and actions. Okay, so here again are opportunities for us to recognize all types of knowledge. Yeah, huge issues involved in that. If amongst you are studying intellectual property law, then you can ask this question: what's happening in the World Intellectual Property Organization at the moment? They're trying to bring a treaty whereby you can actually provide a protection for traditional knowledge. When we say protection, what do we mean? We actually recognize traditional knowledge as an asset as such, okay? So if that's possible, then you'll have some new opportunities for those who are holders of traditional knowledge to have new jobs, to have incomes from their own traditional knowledge, if they actually advise on how to adapt, okay? So notice that there's this emphasis on best available science, okay? So there is a report that IPCC has come up with where it talks about what it means by best available science. Yes, it is all about satellites and prediction of our weather and climate and computer modeling and all of that, but it also includes traditional knowledge, informal knowledge, that is local knowledge in communities, because I might be living here, right? I might be living in the east of England. I'm seeing the weather here daily, and I can kind of even say, oh, looking at maybe in 2 hours' time, because I have the experience of living over here. So that's not traditional knowledge, but that is local knowledge. And then you have indigenous knowledge, right? So indigenous knowledge particularly is attached to groups of people that are considered indigenous, etc. In some ways, you can see we are quite desperate to make sure that all kinds of knowledge feed into how we address climate change, but rightly so. It's been long that we probably have neglected, and we've created hierarchies of knowledge. Another big topic to talk about. 7.6. Parties recognize the importance of support for international cooperation and adaptation efforts. Okay, it's almost impossible, I think, to do to undertake adaptation without international cooperation. Partly because, yeah, if you have a wildfire, it doesn't mean it's going to stop at the borders of territories. So there is an imperative that disasters, when they come, might be across borders. And the other thing is also that international cooperation is necessary because some countries will have more of the capability and some countries simply won't have the capability. So in the spirit of friendly cooperation, if you hark back to the General Assembly Declaration on friendly relationships between countries, there is an international law push towards cooperation. Yeah, so consider that General Assembly Declaration as your ideology behind a lot of the social media. Social media tries to socialize people, right? So our United Nations General Assembly Declaration on friendly relations between countries does the same job. It tries to socialize countries and say, be friends. Marathon article. I told you there's a lot more of Article 7. 7.7. Parties should strengthen their cooperation, enhancing action and adaptation, taking into account the Cancun Adaptation Framework. The Cancun Adaptation Framework took into account integration of different disaster frameworks. So, I mean, climate change is not the, climate change or perception of climate change is new, but disasters don't occur only as a result of climate change. We've had disasters otherwise. We have had earthquakes, we have had other types of disasters. So there are international frameworks such as the Sendai Disaster Management Framework. So Cancun adaptation took into account, disaster adaptation frameworks and integrated it with the new threat of climate change and the massive scale of adaptation that is being seen as a result of this, it is harking back to a previous document. 7.7 is harking back to a previous UNFCCC document. United Nations specialized organizations, this is United Nations specialized agencies, should support the efforts of parties. So the Food and Agriculture Organization played and continues to play a role in desertification, which is an increasing impact of climate change and what that means for food production in regions of the world where they were semi-arid and then now they're tipping into arid regions. So Food and Agriculture Organization has that remit. So people suffering from heat waves, for example, the World Health Organization is another international organization. UNESCO, the Educational, Scientific, Cultural Organization about climate change awareness, education on climate change for various generations. So these are all the different United Nations, organizations and parties. So it's linking that up. Each party, as appropriate, engage in adaptation process planning and the implementation of the action, including development of enhancement of relevant plans, policies, or contributions. So something like your mitigation efforts, you need to have a plan and also implementation. Each party will then periodically submit the adaptation communication. So there's no structure to how this occurs. And rightly so, because your adaptation pressures might also be quite different and occur at different points in time. This could be, like I mentioned, 7.11, it could be distinct from a nationally determined contribution, or it could be as part of the nationally determined contribution. If it is distinct, you could have a national adaptation plan. So in the UK, we have a NAP, a national adaptation plan. And from that national adaptation plan, or to make that national adaptation plan, we also have CCRA, so climate change risk assessment exercises that take place. So we, so for my region where I live and work now, increasing strength of winds is the main climate risk, right? So then this helps me decide whether I can actually buy garden furniture, because I might have hot weather outside, but if I'm going to be battered by winds, there's no point in me having garden furniture, you know, and having a nice cup of tea and sitting outside, a fat chance of enjoying that. So this is the sort of, you know, help that a national adaptation plan can have. So even though at the moment I don't suffer directly from wildfire, which is like, you know, a serious threat to things, but knowing that the winds are going to be high also is going to help me plan, you know, how I'm going to live my life according to it. Adaptation communications referred to in paragraph 10 shall be recorded in a public registry maintained by the Secretariat. Yeah, so it's not just a fulfillment that just goes of an obligation that goes into the Secretariat, but it's also increased disclosure. So we have lots of information. Now, this is very good for those of us researching and those of us studying climate change, whether we're doing legal research or scientific research. There is lots of data for us to be able to use. Or for us lawyers, there's lots of normative background content that we can use to do our various analyses. We still have more of Article 7. Don't worry, it doesn't go beyond, you know, 20 subsections. Continuous enhanced international support shall be provided to developing country parties. So now principles of differentiation kicking in. And then this is the final one. This relates to a global stocktake. We will look at that later in the oversight when we look at Articles 13, 14, and 15. But in Article 14, there is a stipulation of a global stocktake. In that, it should recognize adaptation efforts of developing country parties, enhance the implementation of adaptation action, taking into account the communication, then review the adequacy and effectiveness of adaptation and support provided for adaptation. So it's not just external parties reviewing it, it is also internally, the parties themselves in COPs, in other mechanisms in between various COPs, can also review the effectiveness. But you would expect that nationally too, there will be evaluating the effectiveness. Review the overall progress made in achieving the global goal on adaptation that is referred to in paragraph 1 of this article. Paragraph 1 talked about increasing adaptive capacity, resilience, plotting vulnerability. So those are what the global stocktake in relation to adaptation will have to take stock of. Right, how are we doing for time? Good, good. Next set of provisions in our Article 8, 8.1. Parties recognize the importance. So this is about loss and damage. Okay, Article 8 is about loss and damage. Loss and damage featured in the Paris Agreement itself, but action on loss and damage has come a bit slow, especially after loss and damage actually has occurred in various countries. So some of the key aspects, I've not replicated all of these subsections here, but just a few. Parties recognize the importance of averting. So ideal would be to avert a loss It could be loss of life, it could be loss of property, it could be loss of institutions, loss of countries, God forbid, right? So we have to avert, minimize, and address, okay? So if you can't fully avert it, you minimize it. So here you now start seeing the links between adaptation and loss and damage. Addressing the loss and damage. So you definitely have to address the fallout of it. You either rebuild or maybe you start something afresh. Okay, so these things need to be thought of as distinct, discrete items. Associated with adverse effects of climate change, including extreme weather events and slow onset events. So here you start seeing a differentiation. Extreme weather events might be wildfire, but a slow onset, wind, right? So it has not caused the same type of damage. It's not actually, brought my house down, but nevertheless, it is a slow onset. It is steadily. So I have to then remember, maybe in 10 years' time, I will have a typhoon on, right over here. Role of sustainable development in reducing risk of loss and damage. Yeah. So if a house is brought down by a storm, then what is sustainable development? Do you build another house there, which again is not taking into account maybe new forms of energy usage? Okay. Or maybe it is not built in a way that it can't withstand the elements, right? So that is not sustainable development. Sustainable development means you have to be traveling in the right direction. You can build something new, but you have to consider building that house. What is the emissions involved in the construction of the house? Can I substitute materials? Yeah, instead of using concrete, which leads to a lot of emissions and also a lot of water usage, can I use, for example, a hemp mixed material that I can use in the construction material? So can I actually spend time, effort, and understanding in doing that? So this is just an individual level thing that I'm talking about. I'm not saying Article 8 puts an obligation on individuals. What I'm saying is to give an example of what sustainable development means at a very practical, understandable level. We are talking the obligations under, the Paris Agreement is for states, okay? And that is what international law is all about. So don't forget your international law theory, those of you who know, okay? International law is law among states, right? Of course, does it actually impose obligations on corporate businesses? Does it impose obligations on individuals? Well, we can go into the whole subject of personhood in international law, but that makes it very technical. We're not doing a lecture here on public international law, but remember, all of those principles apply. Warsaw International Mechanism for Loss and Damage associated with climate change impact shall be subject to. So there is mechanisms that has already been set during COP that needs to be extended. There are new developments that have come on top of it. We do have a new finance mechanism around loss and damage. So since Article 8, there are more concrete measures that have been taken to implement Article 8. Right, then we come to 9, 10, and 11. What has this got to do? So the 3 columns you see over here correspond to Articles 9, 10, and 11 respectively. So the first column is all about is content from Article 9. This is about financial support. Yeah, developed country support financially developing countries. Okay, it's not the other way around. So here you have a top-down approach. Developed countries have to help financially the developing countries for both mitigation as well as adaptation. Developed country parties shall continue to take the lead in mobilizing climate finance. Yeah, all the effort behind putting these funds together needs to again come from developed country parties shall biennially communicate indicative, quantitative, and qualitative information relating to paragraphs 1 and 3, which is about how much money they've gathered, what other in-kind they might be providing, etc. So they also have the obligation to report. Yeah. Why is this quite useful? Because it's all, again, this naming and shaming. Yeah, and media plays a very good role in all of this, because every time they report about COP, they just say, oh, they haven't actually made it up to this financial commitment that they said they would do. And that's not the way in which countries want to be considered. They want to be considered as champions of climate and champions of peoples. So therefore, this provision of communication helps us understand which developed country really earned their badges and which developed country just wants to ride on, other countries doing more. Parties share a long-term vision on the importance of, so the second column here relates to Article 10, and this is about technology. Yeah. This is quite crucial because, without the technology, we simply don't have the means to address climate change. Without knowing how to develop and build a wind turbine, you simply cannot build a wind farm, right? So we need technology. Without the technology to be able to capture carbon, there is no hope in hell that we're going to remove carbon from the atmosphere. So there are a lot of mitigation efforts can rely almost completely on technology. And there's lots of very interesting technologies available as well. But what comes with technology? Yeah, with technology comes patents. Yeah, so intellectual property lawyers, you study it because you want to be able to advise your clients how to protect it. Now, patents are not a problem, but if it's patented technology, the reason why you patent it is because you commercialize it. When you commercialize it, you're not going to sell it for, 1 pence or 2 pence, right? The British currency. What's the Russian currency?
Russian rubles, Professor.
And what is the small rubles? I know, but what's the small
rubles and kopecks? 1 ruble contains 100 kopecks, kopeyka in Russian.
Kopecks. I've not heard of that at all. All right.
Kopeyka. This is historical thing. Yes, kopecks have a coat of arms. A chevalier held in this Saint George held in armor. Killing the dragon.
And yes.
Yes, and this thing is a kopyo. That's why the small thing is kopeyka.
Oh,
Kopek.
I see. Oh, very interesting. Thanks for that. Because the English patron saint is also is George, and George is the one who's killing the dragon. Yeah, it's quite a popular, well, not popular, but it's a well-known symbol here too. Interesting. Although we have all sorts of stuff on our pennies. I think the recent lot of pennies released by the Royal Mint actually has Star Trek characters in it. So there's 4 new coins that have been released, 50 pence, which are all Star Trek coins. And then last year we had some coins because we got a new king last year after a long, long time. The previous monarch in the UK was in 1952, and then we had a coronation in 2022, and then we had some coins. All right, okay, rubles. So yeah, we are not going to develop a new technology and sell it for 1 ruble or 1 kopek. When you say technology, that means you already have to think about costs. It's great to have the technology, but who can buy the technology? Yeah, we all feel the pinch when you go to buy a new phone, right? We can never afford to buy the phone that is the flashiest, the phone that you see advertisements for, because they are going to be the most expensive ones, right? So therein, this provision of Article 10 comes into play. In international law, it's not a new or novel provision, right? So right from establishment of the United Nations, we have, as more and more countries became independent and more developing countries started to emerge, then we had this problem of growth and innovation are so connected, and innovation is where technology contributes to. So technology development is one side, but when it comes to addressing it for climate change, a lot of countries that really need this technology do not have the money to be able to use it. So technology needs to be transferred. Again, a highly sensitive area. So again, we see features of international intellectual property law, international development law being integral to addressing climate change. So cooperate, okay? Cooperate on technology development, cooperate on transfer. Well, we saw how cooperation worked when COVID came. What about vaccines? Vaccines is a type of technology. The COVID vaccine had to be developed new. All parts of the COVID vaccine were not necessarily newly developed, but overall, they were actually patented, right? And then we saw what happened. Okay, so that's just an example of a very recent global scale relevance of intellectual property protection coming into highlight because of the right to health, right? And we saw how that played out. Same thing over here. You know, health is one imperative, climate change is another one, etc. Technology mechanism established under the convention shall serve this agreement. This is a power that's granted, but then we don't have a technology mechanism as yet that's been established. So all for future COPs, right? Capacity building, that's the third. So Article 11 is on capacity building. Capacity building under this agreement shall enhance the capacity and ability of developing country parties. So very specifically, it is for developing countries. So this is not something that UK can use, for example, and say, you know, give us money from the common pot and we'll develop our capacity. So it's again quite specifically directed to help and support one group of countries. Differentiation. Capacity building, country driven, based on responsive to national needs. Again, UK will say, you know, to create a whole lot of jobs for a particular type of professional, they might just say, oh, how about I give back capacity build your team on this particular need. But then if it's not a national need in the country to which the UK is offering, there's no point in offering this. So it should be the country that decides, that wants the capacity building, to decide what they want to build capacity on. And often maybe developed countries won't have the capacity to even share because, you know, the needs are quite different. Capacity building activity shall be enhanced through appropriate institutional arrangements. So it should be institutionalized. It's better rather than if it's ad hoc or random. Okay, we're getting there. This is the last part of the key provisions. 13, 14, and 15. Again, the three columns correspond to it. Enhanced framework for transparency. The provisions that we've seen about, you know, putting the adaptation plan or the NDCs onto a registry that's publicly available, but maintained by the Secretariat, is a requirement that stems from this Article 13 for transparency. Okay. 14 is stock take. There's a lot more because I'll be doing possibly the next lecture will be on the topic of what are NDCs, what are the different countries' NDCs, and then we'll look at the process of global stock take because we have just finished the first global stock take in December 2023. So I haven't put much details in here. But what is the purpose of the stock take? Implementation of the agreement, collective progress towards achieving the purpose of this treaty, and to facilitate future mitigation, adaptation, and to recommend what kind of progress needs to be made. So to look at how the NDCs have contributed to the overall situation and then to take it back to say, you need to do more, you need to do more. And that's how we got the word fossil fuels come into the UAE consensus. Because for the first time in this global stock trade, we realized that very specific culprit, if you like, fossil fuels, which directly led to. So we said, right, if we need to take action, if you need to recommend actions going forward, then we need to look at fossil fuels as a problem for climate change that is globally, yeah, and move forward. So you can see how beneficial the global stocktake under Article 14 has been to produce some results in the right direction. And then to implement the mechanism, okay? Now this is about, you might say, right, the implementation is good enough, or the compliance is actually there. But another party might decide, no, your compliance is not there, okay? So how do we facilitate the implementation? Again, no mechanism. The power is there to create a mechanism. We don't actually have a mechanism fully established, but some of the features of how that mechanism should look is already given. It should be non-adversarial, right? Perhaps it won't take the form of the dispute settlement body in the World Trade Organization. That is adversarial, right? So if two countries have a problem in their trade relations, they say, well, you know, you've laid a higher tariff on this product, and that's not right. You know, it should be free movement of goods between you and your country and mine. And then they go into consultation, and then if they don't resolve the issue, then what do? They set up a panel for this dispute, and then there's even an appellate body. But those of us who are international trade lawyers, economic lawyers, know the direction in which that is going now. There's a whole big stalemate going on there. So perhaps not very effective, and perhaps wise that Article 15 is taking a non-adversarial approach and non-punitive approach, punishment, right? Penalties. In international law, in general international law, we also have the word sanctions, right? Now that's another topic. How effective are sanctions? What kind of sanctions are there? Yeah, economic sanctions. How's that going to help? So there's lots of, again, things to go into when analyzing Article 15 and the approach to a mechanism. Well, if it's not all of this, what other mechanism can there be? Might be another question. And that's a topic for another day. Right, time is moving on. So that gives us an idea of the key provisions and the details of how the architectural setup has panned out in the Paris Agreement of 2015. There's lots of other things that we can discuss around 2015 Paris Agreement. These can be how many ratifications? Are there any conditions attached to ratifications? So we know the concept of reservation in an international treaty. So which countries, when they ratified, have expressed reservations and which provisions are there? But that will be taking, you know, too much of a look into just one treaty, and we won't have time to do all other topics, because the legal implications of climate change go way beyond just international treaties, right? So the whole purpose of this course is to have a more holistic view of how the national and perhaps even subnational action is being taken from a legal perspective alongside what's happening internationally. So that's the reason why we can't go further into the Paris Agreement. What is the significance of this agreement? So near universal participation. So we heard this right at the start. So one of your classmates mentioned this. Lots of, you know, all countries are parties, but, you know, majority of the countries are parties to the Paris Agreement. 197, 198, right? So, and it amounts, I think it doesn't actually still cover 100% of global emissions, I think, but it's very, very, very close. All parties have obligation. So Paris Agreement is significant because for the first time within international legal history addressing climate change, all parties have some form of obligation to address this problem. It's a global platform for all stakeholders. Now, when I say stakeholders, I don't mean state parties. I don't mean only states. Yeah, I mean all of those. When we looked at COP23, I said there was more than 88,000 people there, and they all had different affiliations. Yeah, there was a lot from the government, rightly so, because it is the job of the governments to progress the international negotiations and international action. But apart from that, there were a lot of other people. And I said, I was at Sharm, right? I was at Sharm el-Sheikh. So what is my position? I am non-governmental, right? So I'm a non-state actor. So this Paris Agreement provides a space for all sorts of stakeholders and their views to be taken into account. And that, again, is important for the success of climate action, because climate action takes place within the framework of legal rules, and it takes place outside of that as well. Okay. Let me stop sharing this slide, because with that, we conclude all of the topics or items I put in the lecture structure. And let me take any questions or clarifications on today's topic. Is anyone else listening apart from Tamerlan?
Everyone is listening, I'm sure.
Yeah. It is clear. Your lecture was really clear and containing much information. Yeah.
Good, good. These are heavy topics, so thanks for that feedback, because I tweak the lectures based on what feedback I get. If you don't tell me anything particular, then I'll just keep going, like what I do. Yeah, go on. How do I pronounce your name? Tamerlan? No.
Yes, Tamerlan. It's
right.
Because of the guy who comes from Uzbekistan, Amir Timur, the conqueror.
Timur, yes.
And Tamerlan is a Western European name for him.
I understand. I'm used to that.
Yes,
I say I come from. I say I grew up in India, but India is a Western European name for India, like that.
For Bharat.
Yes, Bharat. But if you come from South India, then you have other versions. Let's not go into the politics of it. But yeah, excellent. Yes, I get it. Tamerlan. Yeah.
I have one small question. Yes, I have one small question. As I understand, those developed countries have took an obligation to finance this development for climate change, for reducing negative effects. This means there is some sort of fund. Who rules this fund, and how these developing countries can get money? Maybe they should bring their offers, projects, and it's like project financing. And second question, I'm sorry for putting 2 seconds at one time.
No problem.
Is there sort of market for those countries who want to buy a quota for emission, or how it works? This is individual settlement, country to country, or there is some central place? Thank you.
Okay, the first question is, there's the Green Climate Fund. Okay, it's supposed to be funded up to 100 billion, and there is a dispersing mechanism for the Green Climate Fund, and that is again channeled through states. The second question, this is purely non-governmental. So because it's market-based approach, it's regulated, right, to that extent in terms of some accounting procedures. But there is no central place. There is a central place for some countries participating, but not a central place for the whole globe. So that's what this treaty is proposing, saying you could have a mechanism but it's not there yet. Yeah. And the problem for that, like I said, the pricing of carbon is very irregular and varied at the moment. Okay, the price is actually, the problem is the price is actually very, very cheap, and it doesn't reflect, and it's not the market. So if you look at carbon price and Bitcoin, yeah, do you know the price of Bitcoin at the moment? 1 Bitcoin. That's ideally where we want the price of carbon to be, but yeah, you know, so I think the last I saw it was about 30,000 US dollars is 1 Bitcoin or something, right?
It's now about 48,700.
48 US dollars. I think it was then 30,000 pounds. Anyway, I'm not equating the two, but what I'm saying is the market forces look at how they've pushed the prices up, because that is cryptocurrency is a form of coin. In fact, carbon price is also a form of new money in that perspective. Yeah. So the market-based approach is literally there where markets are, right? And you can, as individuals, people can take part in various markets, but as companies, it will all depend on which jurisdiction you're registered in, because you have to buy into. If you want to know the details, you have to look at the Kyoto Protocol. Kyoto Protocol has been now superseded by the Paris Agreement, but the Kyoto Protocol, the Annex 1 countries, they operated, or the European countries there operated the European emissions trading system. It's a complex area of economics, but that's where you will look for information on ETS. Right. Any other questions?
Yes. Thank you. Thank you. It's clear now, and so I can go and look further.
Yeah, you can look further. There's some interesting work in California, for example, because the state of California has a lot of, is quite a front runner for climate action from a regulation point of view. The government takes lots of actions. They definitely see the opportunity that's presented to them, right? So, and the challenges, involved in setting up market approaches is also evident. So if you want to look at some place outside Europe, they have that's a good a space for discussion that you can look at, right? And you tell me if there's if you find anything else as well, because I haven't gone into the details of it, and I am. Last year I did a project on carbon offsetting for subnational level, but not necessarily looking at carbon markets, but just setting some new institutional mechanisms up for carbon offsetting, so that I can bring in some new funds for mitigation. So this year, again, I might continue doing that work, in which case I would like to hear about examples of carbon markets, other than the Californian one, the European one, and UK has one as well now, because we used to be part of the EU ETS, but because we came out of EU, we also now have a separate trading system, but nothing very lucrative. Okay, any other questions? What time is it?
I have a question, but not necessarily on today's lecture, just on the first essay that we have to write. I don't know if I can ask, or there's a time.
Hang fire, because that's what I'm going to put some slides up for, and you can ask it then. Thanks. Maybe I'll do that now, because I don't want to keep you waiting for too long. Right, let me share. Let me quickly present the right. So for those of you who dropped off from the call before seeing, this is the question, right? Some tips for writing your answer. Get a balance between breadth and depth, right? So it's a 1,500 word essay. Once you get going, you can write. There's a lot of material you can write. But the temptation is to cover a lot of breadth. So don't take 10 different policies, agriculture, energy, transport, aviation, shipping, collect, so don't be superficial like that. Show me an awareness. You may write about 100 words to provide an overview on this sort of 10 different policies. So there's quite a lot of, especially if you're looking at a developed country which takes an economy-wide approach, there will be that many policies because they need every aspect of their economy to be climate resilient and response to emissions. So, provide me an idea. So use, again, 100 words is not set in stone. It's a rule of thumb. What I'm saying is the proportion should not be that you cover a lot of breadth. Yeah, so you need to make a choice of which policy you want to prioritize. And you need to have a reason. That means you need to do the research to find out why you're focusing on aviation policy, right? And often you cannot focus on aviation policy because, UK, for example, claims, or we have set out saying we are not going to take into account our aviation emission. Okay, we are only going to take into account aviation emission from 2033 onwards. So you need to do the research to find out what the specific circumstances are, right? So provide me with an overview, but also then hone in on a particular policy, prioritize it, reason out why you chose that, and then go into the depth. So get the balance between breadth and depth. Remember, what you're trying to do is also identify reasons for a certain data. So you need to be looking at policies that have led up to them, right? Sometimes you might find them in mitigation policies. Sometimes you might just only find them outside of. So read the question again and again and carefully. Because you'll understand the question, but once you do the research and keep going, then you could lose sight of the question. So the trick is mainly to come back to looking at the question after you've done some research. No point in only spending time at the beginning. And when you have done your research, understood how you're going to, what point you're going to make, the most important trick is to structure the essay very well. So the 1,500 words must be structured, overall structure. Then within that, you will use paragraphs, and you need to structure the paragraphs correctly as well. Always use topic sentences at the beginning of paragraphs to convey the summary of the ideas that you're going to be dealing with in that particular paragraph, right? So your structure should come word to word, phrase to phrase, paragraph to paragraph, and then will constitute the whole of that 1,500 word essay. And then the final point is referencing style. Okay. Most importantly, stick to a consistent referencing style. Do not mix the different styles. So in-text referencing, the author, date, yeah, 2 names for it. Don't mix that up with footnote style referencing, which is the footnotes and bibliography. Consistently use one style. I'm refraining from saying this is the style you need to use, but I'm recommending for the type of essay writing, the subject, the topic you're using, and also the type of material you need to present within it. I am suggesting you use the Chicago Manual of Style. I've given the link over here, which you will be able to click on and use. Okay. So, I mean, this is not a style I would use for, doing pure legal analysis, but this first question is not purely about legal analysis. You're not going to be referring much to case law. You're not going to be referring much to legislation in so much detail. But legislation you may refer more than perhaps case law. And the Chicago Manual takes that into account as well, although it's not a specialist legal one. I mean, personally, I would recommend Oscola if it is legal sources, but this is a recommendation. But like I said, choose. You can choose, but be consistent. Or the Russian one, but unfortunately, I can't actually read the manual because the Russian style GOST is written in Russian. So I realized I thought I might take this opportunity to, you know another referencing style, but the manual guide is in Russian, so I won't be able to read. So it's not wise for you to use that either, if at all you use it, right? Okay, so